Mom passes away, and instead of planning a memorial, the kids find themselves buried in court paperwork, fighting over who gets the Los Angeles house, probate fees, lawyer costs, and those new Proposition 19 property taxes start eating away at what should have been their inheritance. In the next few minutes, I'm going to share with you the exact conversations, documents, and trust structure that keeps your kids hopefully united. So the only thing they will argue is just the usual stuff. Hi, I'm Ali Talai, a trust and asset protection attorney and founder of Talai Law Offices. I recently started making videos on social media with the goal of providing educational content that helps individuals and families make smarter decisions about estate planning, asset protection, and preserving generational wealth. I am passionate about helping clients create estate plans that protects their legacy and not just distributes their assets. Estate planning is full of legal nuances that can impact both your family and your financial future. And so before I kind of continue on the video, if you're interested in learning more about estate planning and figuring out how you could actually do a very good and comprehensive estate plan for yourself and your family, I like to invite you to join my webinar, Avoiding the 5 Biggest Estate Planning Mistakes. You can register at talailaw.com under the event page, or simply use the link in the description below. Listen, I have been practicing asset protection and estate planning law in California for over a decade, and I can tell you that some of the most heartbreaking cases I see, they are not from business disputes or creditor issues. They're from families fighting over who's going to get the property after a parent passes away. Brothers who haven't spoken in years, sisters are fighting over mom's home, and adult children are spending their inheritance on legal fees instead of building their own future. The truth is, most of these fightings could have been prevented with proper planning. All right, so I really believe that there are 3 main triggers that turn a loving family into courtroom adversaries. The first one is unclear ownership and documentation. California is a community property state, which means everything acquired during marriage is jointly owned, unless it was a gift, an inheritance, or you sign a valid prenuptial agreement. Without clear documentations, confusion, conflict are almost guaranteed. Second is the unequal treatment without explanation. Maybe you want to leave the family business to a child who's been working in there for 20 years or more, while giving the other children cash or other assets. That makes perfect sense from a practical standpoint, but if you don't really explain yourself, your reasoning, and you don't document it properly, the excluded children may feel cheated and challenge the entire estate plan. Third is what I call sentimental property trap. This is when multiple children want the same item that has emotional value but relatively low monetary worth. Let's say, for example, mom's wedding ring, dad's vintage car, the family vacation home where everyone made memories. That one probably has some actual value as well. These items often cause the biggest fights because you cannot split them equally, and the emotional attachment makes rational negotiations nearly impossible. Before we talk about solutions, you need to understand what happens if you don't plan properly. California Probate Code Section 6401 lays out exactly how properties will be distributed if you die without a valid estate plan. This is called the intestate succession, and it follows a rigid formula that probably doesn't match most of the individuals what they wish would happen to their estate. If you're married with children, your spouse will get 100% of the community property and gets either 1/3 or 1/2 of the separate property, and that will depend on how many children you have. Your children split the rest. If you're not married, your children inherit everything equally. Sounds simple, right? But here's the problem. This system treats all property the same and all children the same, regardless of any of the circumstances. I recently worked with a family where the father died without proper estate planning, and he had 3 children, one of whom had been estranged for 15 years or so, one who had been caring for him full time, and there was another child who lived across the country, but he would come and visit. Under intestate succession planning, each child inherited exactly 1/3 of his estate, including the family home where the caregiving daughter had been living. The result was that the caregiving daughter had to make a decision to buy out the other siblings' share in the family home or just sell the home. I truly believe the most effective way to prevent property dispute is through clear, well-documented communications of your intentions. This goes far beyond just having legal documents that were prepared. You need to create what I call a legacy blueprint. That document will explain not just what you're leaving to them and who you're leaving it to, but why you're leaving it to them. Start with a comprehensive inventory of all your assets. This includes your real estate, business interest, financial account, personal property, and even digital assets. For each significant asset, document how you got the asset, describe what the current value of the property is, and your intended disposition. This clarity alone prevents many disputes. Next, what I want you to prepare is what I like to refer to as a statement of wishes or ethical will. This isn't a legal document, but rather a letter explaining your reasoning behind your estate planning decisions. If you're leaving unequal inheritance, explain why you're doing that. If you're giving a specific item to a specific children, share the story behind those choices. This human element often prevents legal challenges because it's harder to argue with the parents' explained wishes than with cold legal language. I always recommend having family meetings about estate planning while you're still healthy and mentally sharp. Yes, these conversations can be uncomfortable. I understand that, but they're much less uncomfortable than courtroom battles after you're gone. During these meetings, explain your general intentions, address your concerns, and give your children the opportunity to express their preferences about specific items. Strategic use of trust and legal structures. I want to talk about that now. While speaking and communicating is crucial, you also need to make sure you have the right legal structure in place. In California, you can use a revocable living trust. This kind of trust will help you keep the assets out of this formal and long and costly probate process. Keep in mind, having a trust by itself is not enough. You got to make sure that you actually transfer and connect your assets into the trust while you're alive. If you pass away and your assets are outside the trust is still not going to avoid probate in most cases, and so it won't do what you really, really want this trust to do. But you're listening to this video, which means you're going to do those things correctly, or at least, I really don't think this is something you want to do yourself. You want to hire the right professional. And so I'm assuming you are doing those sort of things, and you're going to take my advice if you haven't done that to contact the appropriate attorney and get those things in place. But what I want you to be also aware of that unhappy beneficiaries can still file a petition in probate court, try to challenge these things. So you might want to consider separate subtrust or LLC buckets for each major property or child. This is often more cost effective than setting up multiple standalone trusts. That probably wouldn't make a whole lot of sense. But by having those subtrusts, you can protect against forced sales, lawsuits and credit issues that may come up for the beneficiary. And for family businesses, a private buy-sell agreement funded by a life insurance can be a powerful tool as well. California's corporation code allows you to restrict transfers, and the agreement, that buy-sell agreement or shareholder agreement, lays out the succession plan for children with special needs or those who require extra financial protection. Special needs trusts or spendthrift trusts that follow the required probate code sections could be critical. California real estate has its own unique hot buttons, especially since Proposition 19 took effect in 2021. Now, your child only keeps your low property tax basis if the home was your primary residence and became their primary residence. Plus, the difference between the current assessed value and the fair market value must be within $1 million. If it's above that, that amount over will be reassessed. They also have to file a homeowner's exemption claim within a year of the transfer. Otherwise, the county will still reassess the property taxes based on the date of death value. Tools like qualified personal residence trust or carefully structured interfamily installment sale can freeze estate tax values, but they don't really help avoid Proposition 19 and reassessment of property taxes. Let's talk about creating fairness without equality. One of the biggest mistakes parents make, in my opinion, is assuming that equal treatment means identical treatment. Sometimes being fair to your children means giving them different things based on their circumstances, their needs, and their contributions to the family. For example, if one child has been working in the family business for 20 years while another has built a successful career elsewhere, it might be fair to leave that business to the child that was involved in the business and give other assets to other children, maybe equivalent value. The key here is to document your reasoning and make sure the overall value is relatively equal. I also recommend consider each children's financial situation and needs. A child with special needs might benefit more from asset placed in a special needs trust, while a child with spending problems might benefit from assets held in a spendthrift trust that provides income over time rather than getting lump sum distribution. The goal is to create an estate plan that reflects your values and takes care of each child's individual circumstances, not one that simply divides everything equally regardless of context. When we're talking about estate planning, there's always this emotional side to inheritance, and legal structures and clear documentations are essential, but you also need to address the emotional aspects of inheritance. Many property disputes aren't really about the money. They're about feeling loved, valued, and remembered by the parent. Consider creating meaningful gifts or bequests that acknowledges each child's relationship with you. Maybe one child gets your collection of books because you spent hours reading together. The other one might get the tools because, you taught him or her how to fix a car. These personal touches often mean more than their monetary value and help children feel that you thought about them individually. For items with high sentimental value that multiple children want, consider creating some sort of solution. You might establish a rotation system for using a vacation home, create a trust that holds valuable personal property and allows each child to borrow the items for a special occasion. In my experience, estate planning that prevents family dispute requires coordination between multiple professionals. You need an attorney who understands both California estate planning law and family dynamics. You need a CPA who can help minimize tax consequences. You might need a family business consultant if you own a business, or a real estate appraiser if you own significant property. Don't try to save money by using online forms or doing this yourself. The cost of proper professional guidance is minimal compared to the cost of family litigations. In California, will contests, trust disputes can easily cost each side over $100,000 or more, and they can take years to resolve. Today, we cover the main causes of family property disputes and strategies that actually work to prevent them. I hope you now understand why clear communication is just as important as proper legal documentation, how California's unique laws affect inheritance planning, and why fairness doesn't always mean equal treatment. But here's what we have not talked about yet: how to structure your California real estate portfolio to maximize both asset protection and tax benefits for your heirs. This is especially critical given the changes from Proposition 19 and the current real estate market conditions. The strategies I'm going to share in my next video, the smartest way to structure your California real estate portfolio, could save your family hundreds of thousands of dollars in taxes and create much more flexibility for your estate planning. If you own any real estate in California, this information is essential for protecting your family's financial future. The techniques we will discuss cannot be implemented retroactively, so timing matters, and I look forward to seeing you over there.